paragraph 1. Who are the parties to the contract? The seller. The seller is going to be either a person or a company. I get this question a lot. What if the tax records show an LLC? Well, that means that the home is deeded to that LLC. So you're going to put in, Texas named LLC, whatever the name of the LLC is. Okay. If you panic because you're used to seeing a person's name in there, well, the way an LLC is structured, or a company in general, is that there has to be a person, a physical human being, that is legally able to sign documents for this kind of thing. And that will be the case here. So don't get tripped up with regards to not seeing a name in here. All right. But let's go over another scenario. Sometimes there are two names. So in a lot of cases, there will be a husband and wife. All right. So let's just say here that the husband's name is Tim and the wife's name is Katie. All right. So you put those in, you can click anywhere outside here and they get put in there. Now, here's the deal. Even if the home is only deeded into one name, Texas law is such that when you go to sell a home, even though it may have been purchased under one name, if there is a marriage or even a cohabitation, Texas is a common law state. So that means that both names need to be on the purchase of sale agreement, which is this, the 1-to-4 family. Okay, so even if under the tax records, that home is under one person's name, you need to find out from the other agent, hey, are they legally married? Yeah, but they're separated. Doesn't matter. They have to sign. Both parties have to sign only when they go to sell the home. Okay? So buyer, and this is going to be, I hope this is who I said it was earlier, John Smith, Jane Smith. So again, if Jane Smith wanted to buy this home just for herself, even though she's married to her husband, John, she could actually be on this singularly. But they're going to have not an issue, but they're going to have an extra step when she wants to go sell it because they're married. And both of those names have to be on the contract. Okay? All right. So property, if it's a typical kind of cookie cutter house in a subdivision, it's going to have a lot and block. And that is going to be in the tax records if you can't find it in the listing. Now, in many MLSs, you can't get through a listing input without putting in the lot and block. But if all else fails, go to the County Central Appraisal District's website. Some people call it the CAD, but that is the Bible. That is the single source of truth as it relates to lot and block and legal descriptions of the property. Okay, so let's say it's lot A, block 24. And this line right before addition is the subdivision name. So let's just say it's Westview Lakes. Addition, city of, let's say it is Irving, Texas. County of, let's say that's Dallas, Texas, known as. So they even tell you what this is. You're going to put the address and the zip code, or as described on the attached exhibit, which would be a deed or something of that nature. But 9 times out of 10, it's going to be the address. All right. So Main Street, Let's just say Irving, Texas. Okay. All right. And then it goes on to say what is included in this sale. So paragraph 2 is going to be the property. That's the physical home on the land. And then it says improvements, the house, garage, and all other fixtures. So fixtures is something that's nailed down, right? And improvements attached. That's the key word, attached to the above described real property, including without limitation the following: permanently installed and built-in items. So listen, if anything in any of these contracts is bolded or underlined, the commission thinks it's a big deal to know. All right, permanently installed and built-in items, if any. And then it goes on to explain what those many things could be: all equipment and appliances. Okay, so that's going to be your stove, not the refrigerator, ironically enough, because that's on wheels. But stove, dishwasher, think kitchen appliances, all right? Valances. Those are the things above the top of windows. Screens, shutters, awnings, wall-to-wall carpeting, mirrors. Do you know how many times uh, people decide to leave or take mirrors? Okay, so buyer goes into a house and they go through all the rooms and they see these big ornamental mirrors in the bathrooms, and they wonder why they're missing, or they're still staying, right? So ceiling fans, attic fans, mailboxes, television antennas, mounts and brackets for televisions and speakers. So it doesn't say the TV, but it does say the mounts and brackets. Why? Because they're bolted into the wall. Heating and air conditioning units, security and fire detection equipment, wiring, plumbing and lighting fixtures, chandeliers, water softener systems, kitchen equipment, garage door openers, cleaning equipment, shrubbery, landscaping, outdoor cooking equipment, and all other property attached to the above described real property. So this list has grown over the years because people buy homes expecting things to stay, and they show up on moving day and they're gone. Okay. So I'll just mention a couple of things here is that if you have the reason why some of these things are included is because there's leases on them: security systems, water softener systems. I mean, some of those are purchased outright, but um, people choose to take those things with them sometimes. Chandeliers, that's a biggie. Okay. Any of the smartphone devices, okay, which is kind of what's included here in paragraph C. The following described related accessories, if any, okay, they stay: window air conditioning units, stove, fireplace screens, curtains and rods, blinds, window shades, draperies and rods, door keys, mailbox keys, above ground pool. I mean, can you believe that this actually has to be mentioned? Swimming pool equipment, maintenance accessories, artificial fireplace logs. This is only in here because someone took them at one point. Security systems that are not fixtures and controls for. So you got to leave the garage door open, or how are you going to get in? Entry gates and other improvements and accessories. Controls include sellers' transferable rights to the software and applications used to access and control improvements and accessories. Hardware used solely to control improvements or accessories. So, in other words, the homeowner can't leave a Nest thermostat or Ring doorbell that's tied to all the software and not give it to the new buyer. Okay, that's included, unless you come down to paragraph D and they list, well, you're not taking grandma's old chandelier, or, you're not taking the curtains. I'm taking those with me, or the valances. Those things cost $1,200 each, and I've got 35 windows. I'm taking them. You'd be surprised. So if it's not explicitly called out in the listing, they're included. However, a good listing agent will include that in the listing. This is a huge issue and very hard for your buyer to enforce. If they show up expecting the curtain rods, or I've seen the TV is gone, but so is the wall mount, and there's these big gaping holes in the drywall. Okay, you can't do that. So if it's all disclosed that, hey, I'm taking that Ring doorbell or I'm taking that TV mount, that's fine. But they have to fill in the holes for the wall mount, and they have to replace the Ring doorbell with a doorbell. You can't just leave wires hanging out there. All right, so just to set expectations for your buyer on what's appropriate. So now we go down to the sales price. So this is where some people tend to get tripped up. So there's 3 lines here. So the cash portion of the sales price is just another name for what is your buyer's down payment. Okay. So if they're buying a home for $300,000 and they're putting down 10%, you're going to put $30,000 here. I'm just going to click on the side and look what happens. The sales price is auto filled in. Okay. Now it's up to you to put in the difference between 30,000 and the sales price of what we said, which was 300,000. Well, that's going to be 270. Okay. So now you can see the computer does all the math for you. And in paragraph 3B is where you notate, are they going to, how are they going to pay for it? Okay. Is it going to be a loan? Is it going to be an assumption of a loan, or is it going to go through seller financing? So 99% of the time, it's going to be third-party financing addendum, right? They're going to get a loan from a bank, right? So that is the amount that you're going to finance. Now, I'm not going to review the third-party financing addendum today, but I have another video where I do review this. So all of these numbers have to match what you input into the third-party financing addendum. Okay? So now, let's say that the home was $320,000. That was the list price. And your offer is going to be $300,000. This is going to be reflective of your offer. All right, forget what the list price is. You're pushing over an offer of $300,000. Paragraph 4 speaks to any leases that might be on this property. And this is more common than you realize. And there's 3 kinds. One is a residential lease, which means that there is a tenant living in that home. In Texas, if you buy a home and there's a tenant in there, guess what? The buyer inherits that tenant and inherits the lease that the tenant signed. So that's why this is broken out, because you're going to need to attach an addendum for residential leases. And in that addendum, it's going to give the buyer 2 options from the seller. The seller is either going to agree to terminate the lease before closing, or the buyer is going to accept that lease and the tenant, and the seller is going to convey the lease, the deposit, and all the details surrounding that lease. All right, so please beware if your buyer is buying a home that has a tenant in there and the seller says, oh yeah, they'll be out by closing date. Usually they're not. So that adds a layer of tremendous complexity to a transaction. The other option is a fixture lease. Fixture lease might be, as they say here, solar panels, propane tanks, a water softener, a security system. The one that creates the most headaches are solar panels. Because a solar panel, they can be either owned outright, they can be leased, or the seller could be in a situation where they've purchased them, but they're making payments. The other 4th issue with solar panels is that a lot of the companies that install them mandate that you have to get your power from them. And the one thing that we don't like as human beings, especially in Texas, is to be told that we don't have a choice. And so if your buyer is buying a home with a solar panel, that adds a whole other layer of complexity to this transaction. Because those leases, whether it's a solar panel or propane tank, water softener, security system, or Ring doorbell, any of the things that's attached to your internet wiring, that can create a lot of issues. Okay. So they have to be conveyed and conveyed cleanly. The next is a natural resource lease. So some years ago, it was very popular for oil and gas companies to come in and buy the rights to what lies underneath people's homes for purposes of extracting natural gas and paying that homeowner a dividend from it. And so a lot of times we don't own what's beneath our physical property. And if you bought a home from a builder, that goes without saying. You don't own what's beneath your home, typically. Okay. But that has to be resolved. So if the seller has leased out the mineral rights to the dirt underneath their home, there is somewhere a natural resource lease that says so. Well, that has to be conveyed. All right. And there are separate addendums for all these leases. All right. But this is not cut and dry. So these are the questions that you have to ask the listing agent. Paragraph 5 talks about earnest money and termination option. So it's not mandated in every MLS. So it may not be in the listing, but a good listing agent will put in the preferred title company that they're working with. So paragraph 5A says delivery of earnest money and option fee within 3 days after the effective date, buyer must deliver to, and this is where the title company comes into play. Allegiance title, let's just say as an example, Jennifer Smith is the escrow agent. Okay. And then here would be the address. And the zip code. And then you're going to put in how much. Now, depending on the price, it could be typically 1% of the sales price or some other amount. So let's say it's $300,000, 1% would be $3,000. Okay. And then you're going to say, well, how much am I going to pay for an option fee? And what is that? Well, an option fee is the amount of money that is always non-refundable as a minimal amount to say, hey, I want X amount of days to think about whether or not I really want to buy this home. And in that time, you're going to do inspections and other things that would seal the deal. Okay. And so the question is, well, how much is appropriate? Well, in my opinion, the higher the price the home, the more you should offer. Or let's say that it's a highly sought after home in a highly sought after neighborhood, you're going to want to increase your skin in the game. But it is anywhere between, I don't know, $150 to $500 or $1,000. It really just depends on those other factors. So let's just kind of meet in the middle and say it's $250. And your buyer will make the check payable to the title company, not this person's name, but to the title company, for the total amount of the 3,000 plus the 250. Okay, so 3,250. Now, there are two things that I want to kind of take a step back and explain. Many title companies have the ability for the client to wire their money or somehow electronically send it to them. This would be probably the best practice because it's actually you as the agent's responsibility to make sure that this money gets delivered. Not a lot of people know that, but it is. So the easier you can make it on yourself, the better. Now, the other thing that we always kind of get tripped up on is when is this due? When is this due? So it is due, it says 3 days after the effective date. Okay, then if you come down here, termination option, let's just say we want a 7-day option period. I'm going to tell you that anything more than 7 days, you're pushing it. Okay, unless it's an old home and you know that you need extra time to bring in structural engineers and other experts to assess the condition of the home, you need to get done what you need to get done within 7 days. Okay, so it says that for nominal consideration, the receipt of which seller acknowledges and buyer's agreement to pay the option fee within the time requested, seller grants the buyer the unrestricted right to terminate, which means that your buyer could wake up tomorrow and just decide they don't want the home, and they don't have to give anybody any more explanation than that. The right to terminate this contract by giving notice of termination to the seller within, in our example, 7 days, the effective date of this contract. It says notices, so if you do that, notices under this paragraph must be given by 5 p.m. local time where the property is, by the date specified. If buyer gives notice of termination within the time prescribed, the option fee will not be refunded, and the escrow agent shall release any option fee remaining with the escrow agent to the seller, and any earnest money will be refunded to the buyer. Now, here's where it talks about failure to deliver. If buyer fails to deliver the earnest money within the time required, seller may terminate the contract or exercise the seller's remedies under paragraph 15. Paragraph 15, whenever that's mentioned, means that is when I can take legal action. Okay, same thing goes for the failure to deliver the option fee. So listen, if that option fee is not delivered by the time prescribed, then there is no option period. Okay, there is no option period. So the thing I want you to pay attention to is paragraph 5A2. Because it says it's due in 3 days, right, from the effective date. So if the effective date is, let's just say April 1st. Does April 1st count as the first day? No. So that 3 days starts on April 2nd. So April 2nd, April 3rd, April 4th by 5 p.m. And then it elaborates, if the last day to deliver the earnest money, option fee, or the additional earnest money or option fee falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money and the option fee or the additional earnest money as applicable is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. Okay? So let's say April 1st was a Thursday. So April 1st is a Thursday. April 2nd is your first day, but that's a Friday. And the third day would be Sunday. Well, it says here, if it falls on a Sunday, it goes to the next business day that's not a Saturday, Sunday, or legal holiday. So that would be a Monday. Now, what happens if you execute a contract on Friday and it's April 1st? That would mean that the earnest money is due Saturday, Sunday, Monday by 5 o'clock. What if Monday is Labor Day? Because there's two of those holidays in a year, Labor Day and Memorial Day. It then is due Tuesday. Okay. However, it's my best practice to get that earnest money delivered within the first day. Okay. Got to do it within the first day. That's my opinion. All right. Now, you'll notice that we skipped over a option here where the buyer can deposit an extra amount of earnest money, okay, within X amount of days of the contract. So let's talk about when that might happen. So if the property is, suspect, you want a couple of days, the buyer wants a couple of days to deposit some more money. It's kind of 50-50 whether or not they're going to go through with it. They don't want to tie up all the earnest money. So they, maybe they do half up here and half here. That's one instance where that might happen. Okay. All right. So then it comes down to title policy and survey. So there's two title policies usually in a transaction, especially that where the buyer is getting a loan. There is the seller policy, which is what paragraph 6 talks about. Okay. And the title policy is an insurance policy given from the seller to the buyer that says, hey, no one is going to crawl out of the woodwork 10 years from now and claim a right to the property. And usually the seller is the one that pays it. Okay. Now, maybe if your buyer offers over asking price, it's customary to ask for some kind of, concession there. And maybe that might be okay. Well, we'll pay above asking, but, the seller has to pay the title policy. Or the reverse is true. The buyer offers way under the asking price and the seller says, okay, well, that's fine. We'll accept your offer, but you've got to pay for my title policy. Okay. But in this example, let's just say it's the traditional way to go. The seller pays for it. It's Allegiance title again, let's just say. Right. And it then goes on to say, these are the exceptions that we're not going to insure. All right. And these are basically falls under the heading of these are things that the title company can't control anyway. Deed restrictions, easements, anything that is governed by a higher power, if you will. All right. And then you get down to here where you're always going to want to check this last one. Will be amended to read shortages in area at the expense of the buyer. So this means that if the survey is short in one area or there's some kind of deficiency, guy's fence is on your property, your buyer wants to have the option of buying extra title insurance to cover that. Okay, anything that didn't pop up previously. And just as a rule of thumb, it's usually very inexpensive. It's usually 1 to 5% of the original seller's policy. Okay, so we're talking less than $100. Now, it goes on to say that the title company, they have 20 days to get the title commitment. So I'm mentioning that because agents seem to think that the quicker you can close a property, the bigger the hero you're going to be. Well, when you're exchanging real property, this is something that you don't want to rush. So just keep in mind that if you're looking at a 30-day close, 20 of those days, the contract says the title company has to get the policy done. So better to not rush it. All right, then you come down to the survey, and this is some of the language that's changed. And you'll notice that when we put in the address in paragraph 1, it all carries over to the other pages. All right, so what are the options in the survey? Well, a good listing agent will have a copy of the survey uploaded into the MLS. Okay, and if that's the case, then usually you as the buyer are checking box 1. All right. Now, some people like to say, well, I don't need a survey. My buyer doesn't want a survey. Usually that's because they're in a hurry and they don't realize how important the survey is. First of all, as a buyer, they're going to want to know visually what they're actually buying. Secondly, the title company needs to know visually what they're insuring. So it's going to be rare that a closing happens without the need for a survey. So there is no option for buyer has already received the survey. Okay. So, but if it's uploaded into the MLS, just FYI, that means that the buyer has received it because it's available for you as the agent to download. So if that's the case, maybe you put in 1 day here. But let's say it's not uploaded, but they have it and they just need some time to get it to you. Well, I would put in no more than 3 days. If they have it, then they should provide it. Now, there is also an affidavit or a sworn statement that the seller has to sign that pretty much says this survey is current. I didn't add a pool. I didn't add an extension to my patio. I haven't changed the configuration of the property. Okay. But there is also a declaration that pretty much says the same thing, but it does not need to be notarized. Okay. So, but it does say that the buyer needs to get both of these things, both the survey and either the T47 or the T47.1, which is the declaration, within this amount of time. But it says if they don't, if the seller doesn't provide it, buyer shall obtain a new survey at either the seller's or buyer's expense no later than 3 days prior to the closing. So, if you have to check this, I would say the seller has to pay for it. But I want to caution you that a survey could take a while. Okay, so in some of the rural areas, it could take 21, 25 days. Okay, now in option 2, this is what's changed. In option 2, you could then say within X amount of days of the effective date, buyer may obtain, it used to say buyer shall, buyer may obtain a new survey at the buyer's expense. Buyer is deemed to receive the survey on the date of actual receipt or the date specified in this paragraph, whichever is earlier. If the buyer doesn't do this, it says if buyer fails to obtain the survey, buyer may not terminate the contract under paragraph 2B of the third-party financing addendum because the survey was not obtained. Okay, so let's just say you're going to give them 21 days for the buyer to get their own survey at the buyer's expense. Now, because it says buyer may, they may get it, they may not. It's the closest option we have in the contract to I just don't want the survey. Okay, however, if the 21 days comes and goes, the buyer does not have an out just because they didn't do what they were supposed to do. Okay, and then the last option, within X amount of days of the effective date, the seller at seller's expense shall furnish a new survey to the buyer. So when would this happen? This might happen when, let's say, the seller has lived in the property for 30 years, they lost the survey, or they've made improvements to the property and they know they need a new survey and they've agreed to get one, but they need some time. Okay. And then you come down to 6D, objections. So you don't necessarily have to put in here what most people put in here, which is how you're going to use the property, which is single family residence. Okay, well, this is by virtue of the name of this contract, implied that it's your primary residence. However, we have clients that buy investment properties, or they want to run a business out of their property. This is where you would put this in. So the most common one is rental property. So why would you put this here? Well, it says buyer may object in writing to defects, exceptions, or encumbrances to title disclosed on the survey other than items 6A1 through 7 above. Those are the exceptions that no one has control over. Disclosed in the commitment other than 6A1 through 9 above, or which prohibit the following use or activity. Well, you know that your client is purchasing this not as their primary residence, but as a rental property. What if the city or HOA says that you can't have a rental property, which is common? This is your buyer's out. Okay, doesn't matter if the option period has expired, doesn't matter where you are in the process of this transaction. You can object if you all of a sudden find out your buyer can't use it as a rental property. But then it says, well, when can you do that? Well, buyer must object to the earlier of the closing date or X amount of days after the buyer receives the commitment. So I usually put in 3 days after the buyer receives the commitment. Some agents will purposely leave this blank to try and, run out the clock to say, oh yeah, well, we didn't put any date in there, so they have until the closing date. So I don't really support that. I mean, I think that we should all play fair. So I would just put in 3 days. And then, is the home in an HOA or is it not? Let's just say it is. That means you're going to have to fill out the mandatory membership in a homeowners association addendum. Okay, and remember what I said, if something is in these contracts and it's bolded and underlined, it's important. And it says here, you are obligated to pay assessments to the property owners association if it is indeed in an HOA. The amount of the assessments is subject to change. Your failure to pay those assessments could result in enforcement of the association's lien on and the foreclosure of the property. That's a big deal. Okay. It's an even bigger deal if the seller is currently delinquent in those. Now, that is taken care of before your buyer ever assumes the property, but it could delay closing. Okay. And these, the rest of this paragraph is what people commonly refer to as kind of a flyover dialogue, but it does not make it any less important. If it's in the contract, it's there for a reason. So it talks about membership into municipal utility districts and PIDs and so forth. Okay, transfer fees. All right. Now it also comes down to paragraph 612 here. 6 is it C? 6E. 6E12 required notices. So this is the seller's responsibility, by the way. It says the following notices have been given or are attached to the contract. And these would be things like MUD disclosures. So municipal utility districts, where is the seller getting their water, sewer? Are they in a public improvement district? Because if they are, all these examples mean more monthly fees. And it even goes on to say, seller's failure to provide the applicable statutory notices may provide your buyer with remedies or rights to terminate the contract. All right, so this is a big deal. Well, then it goes on to explain the property condition. Okay, so there is a seller's disclosure notice that has to be given to you as the buyer, and you have to initial it to prove that you saw it. Whether you read it and understood it is another story, but it has to be signed and initialed by your buyer. A good listing agent will include this in the listing. Okay, so there's a couple of options here. First of all, let's just go through 7A. Access and inspection and utilities. Seller shall permit buyer and buyer's agents access to the property at reasonable times. Okay, maybe the seller doesn't think that 8 o'clock at night is a reasonable time, but they cannot deny you access. Buyer may have the property inspected by inspectors selected by the buyer and licensed by TREC or otherwise permitted by law to make inspections. Okay, so seller can't just, well, I don't want anybody rooting around my house. Doesn't matter. You agreed to it here in this paragraph. Any hydrostatic testing must be separately authorized by seller in writing. Seller at seller's expense shall immediately cause existing utilities to be turned on and shall keep the utilities on during the entire time of this contract. You can't imagine how frequently this comes up. Sellers moved out, they've moved on to their future place of residence, and they turn off all the utilities. Inspector shows up, and they realize the water's not on. Some of them may just say, I'm not doing any of the inspection. Some may say, I'll do what I can. And if you want me to come back when the water's back on, I will, but oh, that's an extra $400. So this is a big deal, and you as the buyer's agent have every right to push back if the utilities aren't on. So beware if your buyer is buying a vacant home, because that's the instance where it's most common. So the seller's disclosure notice, either the buyer has received it or they haven't, and the seller has, X amount of days to get it to you. 3 is actually pretty generous. I mean, if they should have already filled this out. But here's the deal with this option. Let's read on. Buyer hasn't received the notice, and within 2 days after the effective date of this contract, seller shall deliver to the buyer. If the buyer doesn't receive the notice, buyer may terminate this contract at any time prior to closing, and the earnest money will be refunded to the buyer. If seller delivers the notice, buyer may terminate this contract for any reason within 7 days after the buyer receives the notice or prior to closing, whichever comes first, and the earnest money will be refunded to the buyer. So this is an additional layer of protection for the buyer if the seller just doesn't outright deliver it at all, or if the seller delivers it late. There is an extra period of time that the buyer has to process what's in that document, and the seller can get out. Or option 3, there is no seller's disclosure required. And let me just tell you this. It's rare that it's not. There are only a handful of reasons that a seller's disclosure notice isn't required. And one of them is not that, oh, it's a rental property and I've never lived here. Doesn't matter. Seller's got to fill it out. However, if it's a result of a divorce and one spouse is deeding it to the other spouse, not required. If it is the result of a death and it's now in an estate, not required. And there are a handful of other reasons. And usually they're all court ordered. But the most common one that people try and use to get out of it is that my seller is an investor and he's never lived here. Doesn't matter. He's got to do one. Okay. And then usually the buyer is going to check buyer accepts property as is, which does not mean that they're not going to do an inspection. You can do an inspection. So why would you ever check this? Buyer accepts property as is, provided the seller at the seller's expense shall complete the following specific repairs and treatments. What if you just know visually after going through the property that you want things repaired that are visible to you at that time? You would put that here. What if it's in the listing, in the description, seller is aware that the hot water heater is broken, seller intends to replace it before closing? Well, you'd want that in writing. So you might put that here as well. By checking option 2, it also does not prevent you from doing an inspection. You can do all that. All right. Residential service contracts, that's just a fancy name for a home warranty. And at the time of this recording, they're all going for about $600, unless you add on appliances, a pool, other things. Okay. So this means that the seller is going to credit your buyer at closing for up to $600. If you want to buy one for $700, the seller's only going to reimburse you for $600. Now, don't you as the buyer's agent buy this policy. Okay. This is up to the buyer. This is your buyer's responsibility. Your only requirement is to say to the buyer, hey, you have $600 to go out and buy a home warranty. Go buy one. Okay. The title company is not to purchase it. You're not to get involved in purchasing it. This is for your buyer to do. And then the buyer writes a check for however much that premium is. And then they are reimbursed on their closing statement for up to $600. And then it goes on to say the purchase of a residential service contract is optional. Okay, in paragraph 8, this is where you as the agent would put in any disclosure as to whether or not you are related to your client. And it actually gives you all the examples where this would apply. Okay, it says, are you acting on behalf of a spouse, a parent, a child, or business entity in which the broker or you, the sales agent, owns more than 10%, or a trust for which the broker or sales agent acts as a trustee, or of which the broker or sales agent or the broker or sales agent's spouse, parent, or child is the beneficiary? Okay. Otherwise, cousins, siblings, all excluded. Okay, you don't need to disclose. Only if it's spouse, parent, child, or business entity. Closing date. In Texas, you can pretty much bank on a 30-day close. But you know, if it's a month like December where you've got some holidays, I'd put some padding in there. Okay. Or within 7 days after the objections are made under paragraph 6D. All right. Now, if your offer, you know, it's going to go kind of back and forth, I would, if, you know, the 30th day, you know, you're not, because your offer is going to go back and forth probably, and you're going to waste a couple of days, I would add a couple of days and make it maybe 32 or 33 days from today. Okay. You also don't know when your seller is going to get a chance to respond. All right, possession. When is your buyer going to take possession of the home? Upon closing and funding, or according to a temporary residential lease. And what is that? That is if the seller wants to stay in the home a little bit longer after closing. All right, and that's a whole separate form. Now, let me just clarify, upon closing and funding, it may close on a Friday, but it may not fund until Monday. When does the buyer have access to the home? Monday. Money's got to be transferred and accepted and validated before keys are exchanged. Okay. And then it goes on to break out the possession of smart devices, because that's the world that we live in. Seller shall deliver to buyer possession of the property in its present or required condition, ordinary wear and tear accepted, in our case, upon closing and funding. Smart devices. Smart devices means a device that connects to the internet to enable remote use, monitoring, and management of the property. Items identified in non-realty items addendum. Items may be in a fixture lease, that Ring doorbell. Okay. And then the no-no paragraph, paragraph 11, special provisions. Unless you have a law degree from Yale, Princeton, Harvard, whoever, you don't put anything in here. This paragraph is intended to be used only for additional information items. What is that? An informational item is a statement that completes a blank in a contract form. What would that be? If the 1 to 4 family residential contract includes between 1 to 4 units, maybe in your address field, it didn't allow you to put every address that's legally conveyed. You could put that here. But anything else, you can't. Okay, because a lot of times agents want to add things in here and they forget about the fact that, well, what if this condition isn't met? Well, I didn't think about that. Yeah. If the condition's not met, what happens? Is the earnest money given back? Well, I'm not a lawyer. Exactly. So please be careful. All right. So under paragraph 12 is where things have changed. This is where this serves as the disclosure for how we're going to get paid. Okay, now paragraph 12 only included any seller concessions in the form of money that would be given towards the buyer as a credit, for things like surveys and things of that nature, right? Your buyer makes an offer, they don't have enough money to close, they need the seller to kick in a couple of grand. And so that hasn't gone away. That's right here. And let's say that in this offer of $300,000, your buyer needs $4,000 in closing costs. Okay. That's where you would put that. Now I'm going to let you in on a little trick. You'll notice that if you just didn't want to put in here NA, I'm typing N/A. Doesn't go in there, right? But if you hit your space bar, this little switch turns on, and now you can put in whatever you want. Okay, so if your buyer doesn't require any contribution from the seller, I'd put NA in there. And the only way you can turn that on is to hit your space bar. So let's read this because it breaks out the seller's obligations to pay certain things and the buyer's obligation to pay certain things. And in that, it mentions brokerage fees. So seller shall pay, meaning obligated, to pay the following fees. So that's going to be liens on the property, any prepayment penalties, recording fees, anything that is typical to a seller's fee. But then it comes down here to say also brokerage fees the seller has agreed to pay. They should have put in here in a separate agreement. What's the separate agreement? The listing agreement. So that's all this says. This is all this is meant to say. It's just meant to say, hey, look, I, the seller, worked out some special deal with my listing agent, and that's in a separate agreement, and I'm agreeing to pay that. I don't have to disclose what that is, but I'm agreeing to pay it as per this contract. Now, you'll remember in the listing agreement, there's an option for the seller to directly pay the other agent, or really the brokerage, right? Because no one can pay an agent directly except for their broker. Now, 9 times out of 10, the listing agent is going to charge a large amount of commission, and they're going to split that with the person that brings the buyer. However, there's an option for the seller to just agree to pay the listing agent X amount. And in one example, let's just say he says, well, you know what, I'll agree to pay you this to list my home, but I'm going to wait until the offer comes in and then I'll decide what to pay the other agent, and I'll handle that myself. Well, if that's the case, then you employ option B. Okay. Because it says the seller shall pay the following expenses and the following amount to be applied to brokerage fees that the buyer has agreed to pay, and I wish they had put in here, to their agent. So because remember, the buyer's rep is an agreement between the buyer and the buyer's agent, and the buyer agrees in writing to pay their agent. That's what this language means. And so if the seller has agreed to do that directly versus just the other agent splitting their commission, well, you could put that here. And that's either going to be a dollar amount or a percent of the sales price. So hear me when I say that if the other agent has communicated to you that they're going to pay, they're just going to split their commission, this is blank. This is blank. NA. However, because of that verbal agreement, you will still have to fill out the compensation agreement between brokers document. And I have a separate video for how to do that. But just because it's mentioned here, oh yeah, I'll pay what I've agreed to pay, you still have to figure out what that is. So if seller pays buyer's agents directly, well, that's going to be right here. But if it's just a split of the seller agent commission, you have to fill out the compensation agreement between brokers. So that's a good segue into what the buyer is responsible for. Buyer shall pay the following expenses, and these are all been in here before. Appraisal fees, loan application fees, origination charges. Well, then it comes down to say, other broker fees. Okay. Brokerage fees that buyer has agreed to pay. And where would that be? In the buyer's rep agreement. Okay. So there is no more disclosure about the amount. It just says seller has agreed in the listing agreement to pay their seller's agents a fee. And the same goes for the buyer. And this is to suffice as a disclosure for that. All right. But again, if you, the buyer's agent, are expecting through a verbal agreement to get paid by this listing agent, you got to fill out the agreement, compensation agreement between brokers. Okay. And then it goes on to describe prorations of taxes. So if your buyer moves in June, well, they're only responsible for the taxes from June forward. The seller is responsible for the rest. Casualty loss. What if your buyer is under contract and the closing is tomorrow, but tonight at midnight, a huge hailstorm is going to come through and ruin the roof? Well, this is what speaks to that. So it says, if any part of the property is damaged or destroyed by fire or other casualty after the effective date, seller shall restore the property to its previous condition as soon as possible, as soon as reasonably possible. But in any event, certainly by the closing date. All right, that's a tall order. That's going to be a tall order if every home on the street needs a roof replacement. If the seller fails to do this, due to factors beyond the seller's control, buyer may have a couple of options. They can terminate and the earnest money will be refunded, or they can extend the time to perform. Performance is closing, right? Up to 15 days after the closing date, or just say, whatever, I accept the property as it is. I want to close anyway. So accept the property in its damaged condition with an assignment of the insurance proceeds if it's permitted by the insurance carrier. and receive credit from the seller at closing in the amount of the deductible under the insurance policy. So the most common example here is roof, but it could be anything. Could be a tornado, could be a flood, right? And then paragraph 15 is the biggie, default. If the buyer defaults, seller has certain remedies. This is the I'm going to sue you paragraph. Okay, talks about the escrow agent being a neutral party and describes what happens if the earnest money is tied up and neither party wants to sign the release of earnest money. Okay, read that paragraph carefully. Okay, and then it talks about federal requirements. If the seller is a foreign person as defined by the IRS code, that means they're not legally able to be here. Doesn't mean you can't own property here, but there are considerations. Okay, if you're not a legal citizen, then you're not connected to the IRS. But if you sell a home that you bought here, man, the IRS wants their money from you as the seller. So there are things you have to do. The agent should know this. Okay. All right, then notices. So what's a notice? A notice is something like a buyer wants to terminate the contract for no reason and they're within their option period. Who is that notice given to? It's not the agent, by the way. So if a notice of that sort is given within the transaction, remember, you as the agent are not party to the contract. So this contact information is the buyer and the seller. Now, there is room for, you can copy me as the agent on it because it's important for me to know, but you put in here the contact information for the buyer and the seller. And then any addendums that you're going to check, usually it's the third party financing addendum if they're getting a loan. If it's a contingency offer, or if there are MUDs involved, PIDs, HOA, all that is included here. And then it says consult an attorney before signing. So I can't impress upon you enough. We are not interpreters of this contract. We are to fill in the blanks, and the signer is to assume the risk. And a lot of people don't want to engage an attorney because they don't know where to go, and they think it's going to be expensive. But if your transaction involves any level of complexity, you need to impress upon them the offset of spending $300 to have a lawyer give a once-over on this versus being out hundreds of thousands of dollars is a pretty easy decision to make. All right, and then the effective date or the executed date. So usually if you, the buyer's agent, are presenting this agreement to the seller, at some point it's going to be in its final version, and the seller is going to be the last one to see it. So 9 times out of 10, the seller's agent is the one that fills this date in. Okay, but be mindful, this is the date where the clock starts ticking. Okay, this is the date that all of the due dates are keyed off of. Earnest money, option fee, title policy, all that. All right. And then this may seem simple, but if you represent the buyer in this example, so you are the other broker. See, the other broker firm is, in our example, us, White Rock Realty. Well, White Rock Realty has its own license number. All right. And then you, as the agent, are going to sign this on behalf of the brokerage. Buyer only as buyer's agent. Okay. The listing is going to be the same, but you're going to have to fill in this right-hand side as well. All right. So you are the associate. All right. If you belong to a team, your team name goes there, your email, your phone number, your license number. And then your broker, or in this case, me, if you're a White Rock agent, I am your supervisor. And then I, as an individual, have my own license number. Okay. And then our physical address, our phone number, and all that. Now, similarly, you can't get out of filling out the listing side. And oh, by the way, the listing agent can input their listing into the MLS without filling this out. So it's in the listing somewhere. Okay, so, and then you're going to check for them. Seller only is seller's agent. Okay, they're not the intermediary. If you're involved, by default, there is no intermediary. All right, and then similar to what this said before, for disclosure only, this is not binding. Pursuant to a previous separate agreement, listing broker has agreed to pay other broker a fee of X amount. This disclosure is for informational purposes only and does not change the previous agreement between brokers to pay or share commission. And then the last page is just a receipted page. You give this to the title company that receives the earnest money and option fee. And they receipt it, date it, which is important because the date needs to be reflective of, hey, they got this in on time. Okay, that, once this is done, constitutes a fully executed contract. Okay, so that kind of concludes the explanation of the 1 to 4 as it exists in its current version as of December 2024.